Well, welcome to Hot Topics in the Workplace when medical conditions strike. I'm so happy that you're joining us here today. I'm Dr. Debra Dupree, IPM facilitator and workplace mediator, and my co-host, Felicia Amenta, workers' compensation consultant. Welcome, Felicia.
Welcome, Debra. Nice to be here.
Great. We're excited for our month of May with a few key topics. So let me tell you about what those 4 topics are that we will cover. And just a couple of things for people to know. We have changed our formatting a little bit. We are pre-recorded. And so we still encourage you to place your questions into the chat box because you will have an opportunity to get our responses because we always send out a recording of our podcast to all of our pre-registered participants. And so if you have questions, don't hesitate to ask them, but you will receive follow-up in our follow-up communication, which usually takes about 5 to 7 working days. So let's get to it, Felicia. I know we have a lot to cover today. Okay.
Great.
So first of all, May is Mental Health Awareness Month. So what do we need to know about that? Number 2, workplace bullying, psychological safety, FEHA exposure after AB 2053. This is a law we're still all getting very familiar with. And we're going to touch on what to do before it becomes a workers' comp case. Number 3 relates to pregnancy disability. There have been some cases around forced leave because you're simply pregnant, as well as discrimination. And also how to, what happens when there's a failure to engage in the interactive process. Remember, the interactive process is designed for all medical conditions, temporary or long-term. And number 4, helping you to wrap up this fiscal year, we're going to talk about what are some key steps about who's on and who's off, whether it's in your reasonable accommodation process or who's off of work, who's getting ready to come back, because then we prepare for the next fiscal year. So those are our 4 topics, and let's get right into it. Okay, mental health continues to be a very hot topic. And again, oftentimes employers just don't know what to do or how to handle it because it seems so sensitive or confidential. And it is, but it does require handling it with diplomacy, tact, consideration, and compassion. So I know, Risha, you've got some court cases to share with us.
I did find a case that I thought was interesting on point. This is Roby v. McKesson Corporation. And this particular employee, Charlene Roby, worked as a customer service liaison for this company. And she began suffering from a panic disorder that required medical treatment. She was having trouble controlling the panic attacks and caused her to miss work. And her supervisor disciplined her, wrote her up, and then fired her for taking what they felt was excessive absenteeism on the job. And then she sued the company, claiming disability discrimination and harassment in violation of FEHA. And she presented a lot of evidence, different evidence, what she claimed to be unfair treatment. And there was a lot of different things that she brought up that she claimed to be unfair, that they were giving gifts and food to other employees, but not her. And that her company required her to answer phones during the company Christmas party when everybody else was enjoying the party. And that they called the physical side effects of her disability disgusting. And they ignored her at staff meetings and told her that she needed to bathe more often because some of the medication gave her kind of an unusual body odor. So this was kind of a different kind of a
Wow.
case. But again, it's already involving mental health issues, and
Yes.
there's a lot going on. And then company belittled her and disciplined her in front of other employees, which she
Mm.
felt. And then there was a back and forth. This case was appealed, and the jury found in favor of her. And then ultimately some things went on with the award. but ultimately they found for her against McKesson Corporation for a little over $2.8 million. And the
Ooh.
jury ruled for her on all claims. And it went all the way to the Supreme Court, but they still upheld the ruling for her. They just
Mm,
reduced the award to about 1.9 million. And there was a lot going on there, but that's not really the point of what we were saying.
mhm,
What really helped find in her favor was all of this treatment, because she was filing for disability discrimination and harassment. A lot of this behavior, and this is, I don't believe was a work comp case, but it wouldn't have mattered, right? Whether it's a person filing a work comp stress claim or whether it's a non-industrial stress claim, you want to be really careful about the messaging, right? And so
mhm,
obviously she was able to prove a lot of these things that she felt that they were treating her unfairly and
mhm,
that's one thing that they were saying you have to really watch out as to how you message and how you communicate and
mhm.
how you treat people that have already come forward with mental health issues, not sort of double down. And
Yeah.
this was not that, right? This was almost
Mhm.
opposite, almost like she felt like she was being singled out, right?
Yeah. Yes. And, unfortunately, because I've seen many cases like this in my day-to-day work where, intentionally, unintentionally,
Mhm.
oftentimes unintentionally,
Mhm.
people, leaders are afraid. They don't know what to do. And
Mhm.
unfortunately, they don't seek counsel either through someone like myself or you or attorneys on how to handle it. And now, one thing I do want to point about the case is that it was very appropriate for them to initiate disciplinary practices. Definitely.
Mhm.
However, I imagine there probably was evidence early on that a medical condition was causing or contributing to the increased absenteeism, et cetera. And that's then when they have knowledge of a possible potential medical condition that are driving these factors. And so then you sort of pause the disciplinary procedure and you implement the interactive process to get more information. And then that's where they would have worked with her as far as, okay, what are some temporary accommodations? What's needed? Because obviously, chronic unexpected absenteeism is not doable, is not sustainable, and it's not manageable. And
Mhm.
so having knowledge is when you have to instigate that. Absolutely.
And
Yeah.
so obviously what you and I know is we see a lot of cases where anxiety and panic disorder are the underlying mental health conditions, and they can make it hard to do any kind of a job, including
Mhm.
customer service liaison who's out facing with customers, right?
Yeah.
So it does have to be communicated with and really start looking at the elements of the essential functions of that job and if there are maybe something else they could do to
Right.
accommodate.
Right. I'll just share with you real quickly another case that hasn't gone to court or anything, but is very indicative of, I believe, a good early activation of the interactive process. It was shortly before Christmas, where a teacher was observed to cross the parking lot and demonstrate some imbalance issues, and had to, people, sort of rushed to her, and she reported feeling highly anxious and having a panic attack. And so
Mhm.
they did call 911 because they had no idea what was going on. But then Christmas break happened, and then we did meet in January, and she acknowledged that she had seen an increasing pattern of more anxiety, more panic attacks, but had not sought active treatment for it. And so we
Mhm.
gave her the opportunity to, get to her doctor. Well, it turns out that she acknowledged she had just started seeing a psychologist and a psychiatrist, so was just starting anxiety medications. And so we gave her an opportunity to go to the doctor. And I actually don't remember if she was taken off of work at that point. And then another incident happened. Well, she did continue working. Another incident happened in March with an unexpected fire drill. Sort of panicked and froze and was unable to carry out her duties and getting herself and her students safely to class. Other people had to intercede. So we came back. Turned out she didn't go to her medical appointments in March because her anxiety was too great, but she was continuing to work. So she was stayed off and paid admin leave. And it was agreed, since she was given the opportunity, provided no medical information to substantiate, we proceeded with the fitness for duty. Well,
Mhm.
right before the fitness for duty, though, and by the way, her physical doctor had released her to return to work in the meantime. Well, then it came back right before we were going into the fitness for duty that the anxiety was actually secondary to an underlying physical condition. And she was just now starting treatment for the underlying physical condition. So we were able to cancel the fitness for duty, say it's premature. Because if the anxiety is arising out of yet another condition, she needs to treat for that first condition. And so she did go off work using sick leave, to which she objected. But it's like, well, wait a minute, your doctor is taking you off of work. Well, I can do modified work. Well, no, we can't put you back to work if your doctor has said no work at all. So we'll reevaluate before the next school year starts. But again, that's, I feel, a really good model of early intervention and monitoring, working with the employee. And keep in mind, all of our listeners and viewers, the employees have a responsibility of providing timely documentation to support. Otherwise, you have to move forward with your other like disciplinary action or taking them off of work, even with paid administrative on a temporary basis and so forth. So, but again, her safety, the safety of others. But it was she kept presenting a mental health condition, but it turns out that it was driven by an underlying physical condition. So, got to have a bird's eye view, from that perch up above and taking a look at the whole thing. So, okay, moving on. Now, I know you've got some cases around this. I've got another recent situation I've been working with, workplace bullying, and what AB 2053 is all about. So what can you share with us about some recent court cases, Felicia?
This is a case, it doesn't really involve bullying, but it involves, I guess, her allegation that they were not treating her properly. This is an older case, but it came into litigation more in the current time. This gal worked for Neiman Marcus. She'd worked there for a long time. She got transferred to a new store. She was having this wasn't really a mental health case. She was having a lot of problems. She was having mental health problems, but she was also having back and joint pain and all kinds of problems. But there were doctor's notes that were saying that she couldn't work at all. And then there were doctor's notes saying that she had to work a shorter time, shorter shifts than what her normal schedule was. And this case was interesting because the doctor kept writing her off, right? And then the one thing I have to say in this case, Neiman Marcus kept meeting with her, IPM after IPM. We got a note. The doctor says you can't work. What essential functions can you do? Communications with the doctor. What essential functions can she do? She was eventually, and she was given additional leave. Like in your case, right?
Yep.
She used all of her leave. They gave her additional unpaid leave. They gave leave beyond FMLA. She sued them, claiming harassment and discrimination against them for her disabilities. But it was very interesting because in this particular case, the court found for Neiman Marcus because they said, the doctor's notes were really where the crux of the case lie. As the doctor's notes, the doctor kept saying she couldn't perform the essential functions of the duty. And they said, what duties can she perform? And he was saying like none. And so he was really stating she was very limited. And even in the IPMs, she would say, which you and I have seen many times, I don't think I'm ready to come back to work. I don't think I can work. And so coming from the employee, and what Neiman Marcus kept saying was, well, maybe you can reapply when you're feeling better, when your doctor restrictions change. And so in that particular case, the court found for Neiman Marcus because of the fact that they had met with her so many times. They called her, they communicated with her, they wrote her, and the store provided additional time, even beyond the requirements of FMLA. That went a long way to showing real attempts at cooperation. And the doctor's note obviously provided a lot of limitations and that he was concerned that she couldn't work. And so the case was very interesting for those reasons, right?
Yeah. Well, I think, one of the underlying messages I'd like to emphasize on that, Felicia, is that, the whole goal of all these laws, is to help people continue working even when medical conditions exist. And so I just had this in another case too, where the employee's doctor said no. And the employee goes, but I think I can. I said, well, then that's a conversation between you and your doctor. We don't have the authority to override a medical doctor's findings. and if you disagree, then you have other options, but we can't overturn that. And so that's one example. Another example is where, particularly around this case that I want to emphasize about AB 2053, it's only 2 years old. And,
Mhm.
and maybe you can say a little bit more about, the JPA's role in that, in helping employers, and, from your former role with the JPA as manager. But I have a situation too. Again, the situation actually started about 2 years ago, and it was actually between a parent and a certificated employee. And it's a smaller school district. And the employee was the only employee of its kind. So
Mhm.
very specialized duties. And and so she voiced her concerns, and the school attempted, but then there's limitations about under the education code about what parents and students' rights are. So it was a very tricky kind of
Mhm.
situation. They wrote what they call cease and desist letter, which led to no change in behavior on the part of the parent. But with AB
Mhm.
2050, then it actually does permit employers to file temporary restraining orders on behalf of employees when they are being threatened or harassed by agents to the employer. So that could be parents or students or vendors or anything like that. And because that AB 2053 provides protections for when workplace issues that haven't really given rise to injury yet are
Mhm.
occurring, but could be threatened to. And unfortunately, time and circumstances, and the employee did ultimately file a workers' comp case, and
Mhm.
which is appropriate. And so we did an IPM, and of course there was a lot of blame for what the employer didn't do. And it was, well, wait a minute. And I already brought up AB 2053 to say this is all pretty new. And this has sort of changed the dynamics about what you've experienced. And hopefully we'll just get better and better, just like all these other laws, like with the ADA and
Yes.
workers' comp. So anyway,
Yes.
it's so I'd like to hear what you have to say, as far as what the JPA is doing for its districts.
So the districts can use a template that the JPA has to modify um, a training that is specific to their workplace and their sites, because that's what they have to do. And they have to have a written policy in place as to how they're going to deal with the complaints of workplace bullying and the psychological safety. But this is all, you're right, very, very new. And that is mandatory training that has to be given to all employees, and then logging in all of the incidents and handling the complaints. Obviously, before the new law came into effect, we had issues of workplace bullying going on either between parents and employees, employees and employees, and families of employees and employees.
Yeah.
So we were dealing with the issue, but not in a specific law. I have seen a lot of very interesting accommodations around this issue. A lot of the doctor's notes that I see with these bullying issues, especially if it's a parent that's front facing either with a certificated teacher or staff in the front office, they'll transfer that staff member to another site,
Yeah.
not another job, another site. So
Right.
that parent or that person, they're not dealing with them anymore temporarily while we treat them and work on the case. I have seen other districts keep them off and keep them at home.
Yeah.
So to say what's better is I think each and every case is very unique. But you're right. Usually they're not taken off work completely. That's not what we see sometimes, but that's rare. Mostly their treaters want them to continue working.
Yeah.
They
Hmm.
just don't want them working around the person who is causing them to be afraid or who
Hmm.
is acting out. And in the one case of the case we had, it was a parent, same thing, versus it was a front office staff, not a certificated teacher. And so this parent could come in like any day. So they were always afraid they were going to come in, and they had had several altercations. And everybody found this parent difficult. Like it wasn't
Right.
just this employee. And so that was the note that we got requesting accommodation, was that she be moved to a different physical site. And this
Hmm.
particular district is not small, they're big, they have lots of sites. And that's what they did during her treatment and while she was getting better. And then you know what's happening in the treatment,
Hmm.
as a counselor yourself, they're working on resilience training and
Mm,
how to deal with people like this. Because unfortunately, if you do work in the front office or you do work as a certificated teacher or a staff member, you are dealing with the public. So then they're working on some of those confrontation skills and what to do to diffuse situations and where
mm.
to go up when you're having these kinds of complaints.
Yeah, yeah, yeah. And that's something like in this last case I just referenced is suggesting some treatment options that they might want to explore if their doctor hasn't already addressed that, because this won't be the last person. And that's oftentimes what I say in situations like this is that, well, we need to develop our resiliency, our skills in dealing with difficult people, because the kind of behavior isn't going to go away. The person may change, but not the behavior. And I think one of the things about this too is that if we can try to keep in a way, it's like when we talk about removing from the person, it's like any job, removing them from the risk factors that prevent
Right.
potential harm or injury. It could be an exposed wire. Well, you're going to remove them while you fix it. And so again, remove them from the circumstances that are contributing to the underlying conditions. And it's only with that removal and then with the person developing skills. And then, again, it could be backlifting techniques, it could be,
Right.
ergonomics, again, building their skills to deal with things differently so they don't revert to the same old patterns.
And I always supported, of course, ultimately the school has to make the decision what works
Mm,
best for them, is trying to accommodate them if they can, because sometimes sitting home when you're already
mm,
having these kinds of issues does not actually help you. And I told them that is why the doctors don't take them off work. They
yeah,
want them to work. They just don't want them to work around the situation that's causing the
right.
super high anxiety and mental health problems. And if you can put them somewhere else, if you can, that is
Mm.
far better sometimes than just leaving them at home, because where they're isolated, might not be getting the support that they need.
And that whole philosophy, Felicia, is very consistent with our whole temporary return to work program. Again, we know that being at work actually can help people improve more quickly and efficiently, provided they're not exposed to the same kinds of stressors or danger points that they were that led up to their injury. And so, but again, I'm going to put my caveat in there, but again, don't just do temporary modified alternative work indefinitely, set some time frames so that they're not showing improvement, even in a temporary alternative capacity, then it's not working. It's not helping them improve. Okay, I got a chance to say that once again. Okay, number 3, it's all about pregnancy discrimination, and again, forced leave, failure to engage. I've got a couple of real life examples too, but let's hear about the case law.
There's a lot of cases on this, actually. I have like 3 cases. I was like, wow, I had to like pick between them. So we'll take the first case. This is EEOC versus Wabash National Corporation. They're a big national, they make semi trucks and trucking equipment and trailers. So EEOC filed a lawsuit against Wabash, this maker of trucks, for denying a pregnant employee's accommodation request. She requested from the company to transfer to a role that didn't require her to lie on her stomach. I was trying to think last night of what your job would be, that was an essential function, maybe that you're working on the trucks or something. But anyway, her job required her to lie sometimes on her stomach. Instead, the employer forced her to take unpaid leave and gave her no choice but to return to her position without any modification. The employer's decision to deny all accommodation requests caused her to fear for the health of her baby, and she was forced to resign at 8 months pregnant. So she lost her job and she lost her health benefits, which is
Oh,
not good when you're 8 months pregnant. And the company also unlawfully requested medical documentation from her of her pregnancy and failed to accommodate, even though it could have provided changes similar to what they provide for non-pregnant employees that have similar limitations to hers. Apparently, there were some other people that had some similar limitations. And the EEOC, this case is still ongoing, said that this violated not only the Pregnancy Workers Fair Act, the new act, but the ADA as well, because they didn't offer any other solutions other than you're leaving. And per the EEOC, they wrote a strong message, like they always do at the bottom of these, of what not to do, employers. No one should be forced to choose between their livelihood and the health of their pregnancy. They felt that they didn't offer any alternatives. They didn't meet with her. They didn't have any discussions. And as we know, it's partially the employer's responsibility. It's not the employee's responsibility to come up with what accommodations you can do so I don't lie on my stomach. And yeah, so there was a discussion of settlement, and they couldn't reach a settlement, a preliminary settlement like the EEOC does sometimes. They didn't take that option. And so they're litigating against the company. So we'll see where that goes. But that was kind of an interesting case, I thought.
Yeah. Yeah. Very interesting. Like you, when you said no lying on your stomach, what job could she be doing?
Yeah.
I know a lot about the world of work, but okay.
Yes, you and I both. I really thought about it last night because I saw a lot of job analysis, right? With a
Yeah.
lot of the job duties broken down. And I could not think about what kind of a job you do making trucking equipment or trucks, but maybe somehow in the, I don't know, maybe somehow in the assembly of them or something you're doing it.
Maybe. Anyway, that's not the point of the case anyway. Yeah. Okay. Well, I'd like to just share, a recent situation too. And again, an example of where an employer did do a really good job. And I bring this up because many of our listeners and viewers are from the educational environment. And so, and we see this come up not just with pregnancy, but in other situations too. But so, yeah, we have an employee who actually is not due for probably at least 6 more months, but had some early pregnancy complications. And so the doctor did come back with a note saying, certain things. But one of the limitations, but she could work, but one of the limitations was to be removed from environments where she might be exposed to combative or aggressive students. Okay, we've all heard that one before, right? And in her role as an instructional assistant, that's exactly what her job was all about, is working with students with special needs that range anywhere from mild to severe. And so it was on the other limitations could be readily accommodated, like the need to hydrate and the need to be able to sit down as needed. That was doable. But it was be removed, not to avoid, be removed. And so, and while she didn't quite understand that at first, we just said, we have no choice. We cannot keep you in your usual job in that kind of classroom. So what alternatives are there? Well, this particular, district always has a need for what some places will call noon supervisors, who are monitoring students during play and during lunch and so forth, to be the eyes and ears and basically have a physical presence, but they're not really responsible for engaging with difficult students. And so, and this is the general ed population. But the job only is 3 hours, is at a lesser pay than the employee's usual job. And so she immediately started to jump to conclusions like, well, no, wait. During temporary accommodation, which this is because pregnancy is a finite period, you probably can expect to work until October. Of course, we've only got a few weeks left of the spring. We then start the new school year, so you have a few weeks off. Your limitations may be very different when it comes time to coming back to school, because you'll be further along in your pregnancy. For right now, on a temporary basis, you will be offered the noontime supervisor. It's all within your limitations. You can sit as needed, and you'll have 3 hours of actual work, so you're not sitting at home. You'll be paid at your usual rate.
Right.
And then, well, the thing though is that because she'd already used her sick leave for this fiscal year, she then automatically went into the education code's extended leave of 100 days at half pay.
Oh, because it wasn't, it wasn't her full salary schedule.
Yeah. And so she said, well, that doesn't seem fair. It's like, well, wait a minute. Your employer is offering you work. They're keeping you in a paid status. You get all of your benefits. It's just not the same because of what your doctor has said.
And what you and I have seen, a compromise is necessary, and it's a temporary compromise. It's not a permanent compromise. One of the other cases that I looked at that I thought was so interesting was there was a gal This is young B UPS. This is another EEOC case that's working its way through. And Peggy Young was a part-time UPS driver, and she became pregnant, and her doctor restricted her from lifting over 20 pounds early in her pregnancy temporarily, and eventually to no lifting over 10 pounds a little later on. So let's just say, like, maybe the first trimester, it was over 20 pounds, but no lifting over 10 pounds as she got into her second and third trimester. And UPS requires their drivers to lift up to 70 pounds, and they refuse to provide her with light duty work. And she took unpaid leave during this time, but she lost her medical benefits, which if you're pregnant, again, this is a big problem to cover. Pregnancy is expensive under group medical. And she said that they'd accommodated other drivers for this no lifting restriction, and that she sued under pregnancy under Title VII and the Pregnancy Workers Fair Act. And so the Supreme Court held that she could establish a Pregnancy Disability Act claim because, one, she belonged to a protected class because of her pregnancy.
Oh, well.
Two, she sought an accommodation, and they didn't come up with alternatives for her. Three, they did look, and there were other cases where they had accommodated this no lifting restriction for, like, workers' comp, right?
Yeah.
Other issues on a temporary basis, again, on a temporary basis. And the pregnancy was a temporary condition as well. And the court stated that employers must provide legitimate, non-discriminatory reasons for treating pregnant employees differently than other employees that are injured or disabled.
Right.
So I thought that case was really interesting too. Same thing though, not working with that work restriction and offering maybe other jobs other than driver, or looking at other ways to do it. And they had done it for other people. She knew it, right? Because
Yeah,
she
yeah.
worked there for a while.
Okay, so definitely the precedent setting for sure. Yeah. If you just go back to the basics of the Americans with Disabilities Act, again, it says disability. Anybody who's listened to me before know that using the word disability is really not part of my nomenclature anymore, and hasn't been for probably 15 or 20 years. And because a lot of times people may have a medical condition, but they don't view themselves as disabled. And it also doesn't address disability is oftentimes viewed as long term. And that's where a lot of the early days of ADA, early years, I should say, with a lot of quibbling in the courts about whether or not it was protected. And it's like finally the court said, move on, accept it as a medical condition, but the law language is still the same. And so if we look at pregnancy being a medical condition, aka disability under the original law, or even going back to Title VII and 64, then again, this is where the nuances of, it's a medical condition. You have knowledge. You have an obligation to do something different, and then that's why the Pregnancy Workers Fair Act came out, because there are unique circumstances, just like FMLA, unique circumstances that are related only to pregnancy. And again, it's temporary. It's 9 months, but at the same time, it doesn't mean people are incapable. And so that's the other thing during a pregnancy, is being flexible in the accommodations and knowing that it will progress. It's not atypical for someone to have lifting limitations increase during pregnancy, just as a safeguard. So, yeah. Right. So again, we have general practices, but each case is a case-by-case analysis. Yeah. Right. Which actually leads us into our fourth topic, Felicia, because all of this is medical driven. And so, as employers wrap up their fiscal year and then prepare for the next fiscal year, and staffing, and particularly in the educational system, because that changes every year with the student population and program changes, what are some best practices that our listeners and viewers can consider as they, here we are, getting close to the end of the fiscal year? What are some things they can still do and then prepare for the next year?
I always recommend that in April or May, which we're now into beyond mid-May, can't believe it, almost the end of the fiscal year, that what employers need to be doing, especially public employers, where we're coming into the end of one fiscal year and the beginning of another, is taking a look at who's going to be off. And this meeting, I think, should be held with HR and with risk,
Mhm.
together so that they're working together on taking a look at all of the employees, whether they're injured by workers' comp or whether they're injured by non-industrial disability, and to prepare for the summer break and the end of the fiscal year to look at where the employees are at in their accommodations on modified duty count before we get to the summer break, and where are they at with their ed code of their 60-day count, if they are eligible for the 60 days of full paid industrial accident leave per the ed code, and are they working in the summer, and is there anyone that needs to be notified like workers comp or HR about their benefits if they are, and do you need to schedule IPMs before they go off work and you don't have access to them until the fall start of school. And then you can take a look and discuss with all those people what they're working on and where they are with their medical treatment without violating, medical confidentiality as far as their work status and what they're working towards over the summer. And then you can establish a timeline, and then they know where they are as far as their count for all those things we just talked about: workers' comp,
Mhm.
temporary accommodated duty, the 60 days of IE leave under the ed code, and their 100 days, right? If they're into their 100-day leave, where are they at with that? What you don't want is to have people that are running out of their leave and are going to lose their job and their benefits, and you haven't even talked about it. And you certainly don't want to have that happen at the end of the school year and they don't even know that they're in that kind of dire predicament. So I always think making a list is the way to start, and where they are, and then seeing who you need to meet with, then meeting together about all of the employees that you have in this situation, and then deciding who you need to meet with, because you're very quickly running out of time now. Some districts may only have a few weeks, right?
Right. Yeah, it's just a good idea to check on where people are. And one of the things I'd just like to really emphasize, as you mentioned, you know, getting to the end of the 100 days before you even meet comes as a real shock to
Mhm.
employees when they are not fully aware of just what is happening. And in many times, they're still grappling with good recovery. And so, how do they deal with that? And it's when people are, well, it's like any situation, when people are caught unexpectedly, unaware, feeling uninformed, feeling like their employer didn't do enough. Unfortunately, that raises the potential for litigation, whether
Mhm.
it's under workers' comp or the employment law or any of the other applicable laws. And so, again, that communication piece is key
Mhm.
in terms of maintaining good relations with your employees, and and can really, my experience after doing this for so many years, I worked particularly with a power and water utility for about 18 years.
Mhm.
It was a journey, because I helped design and implement the program, and then stayed on to guide and coach them through many, many situations. But while there was initial resistance from the union, believe me, everybody came to love that program because it helped preserve jobs with one
Mhm.
of the best paying employers in the region. And employees were just so grateful for an opportunity. So you end up developing a really loyal, staff, and actually it increased the community's what do I want to say, PR, or the
Mhm. Oh,
it did
absolutely.
PR with the community, and they really became recognized as a model employer.
And if you do this right, this whole situation, your return to work, your temporary accommodated duty program, your return to work program, and your IPM program, you can get a much better relationship with your unions and with your bargaining and your negotiating, because they can see the efforts that you're making. I think that one of the things that I saw a lot of litigation is districts not understanding that work comp ends after 2 years. You're not on work comp anymore. You have to
Mm-hmm.
go over to these other benefits, even though you
Yeah.
still have a open work comp case. That
Mhm.
didn't used to be the case. Work comp
Yeah.
kind of went on indefinitely, but that has not been the case now for a long time. Now,
Right.
104 weeks and you're out and you're out, and that's it. And so you want to be counting. And if you think to yourself as you're sitting listening to our podcast that you don't know where all your disabled employees are with regards to these leave, then you really do sit down and make a list and start meeting with your team and try to figure out where they are. You should immediately know, as you're thinking to yourself, that you know on a grid where everybody is and how close they are, and that they know where they are and how close they are to running out of benefits. And that includes your people that are on workers' comp, because they're still counting and going through other types of leave as well.
Absolutely. And, and by, good effective management, you have an opportunity to save your organization countless dollars. Like I won't even
Mhm.
begin to say thousands or maybe even millions. And,
Mhm.
and so again, a lot of wasted money goes without properly managing and tracking where people are. It may be an initial investment if organizations haven't been doing this, but boy, it sure pays off in the long run. Yep. Yeah. Well,
Well,
there
and I
you
know you and I just worked in my former position with a smaller school district that didn't have really a light duty return to work policy. And they said, we think we need one. We have run afoul, we've run into some really complicated cases. And you're right, they went and got some other policies from other districts and then crafted a policy, and then are working very well, within establishing a practice. So.
Yeah. Yeah, it can be a real boon to business, employee morale, and just save a lot of headaches,
Mhm.
particularly legal wise. So there you have it, folks. We our 4 topics for today, and hope you find this enlightening, informative, and something to take action with. And as a reminder, our pre-registered participants will receive a live recording. Any of your questions, we will get back to you. We will include references to the cases that Felicia cited here today. And so please join us again in another month, second or third week of June. And then as a reminder, we will be taking a break in July when many of our listeners and viewers are on summer break. But to give everybody a respite from this process and then get ready. And here we come back in August. So
Mhm.
thank you again, Felicia. Any last
You're
words?
welcome. Bye, everyone.
Okay. Okay, thank you again, Dr. Debra Dupree, IPM facilitator, co-host with my good friend and colleague, Felicia Amenta, workers' compensation consultant. Thank you again, and we'll see you next month.
Bye, everyone. Happy summer.